Honorable Supreme Court of the Philippines shall give their attention, for the court is now in session.
Your Honors, good afternoon. This is a continuation of the oral argument of the 37 consolidated petitions assailing the constitutionality of Republic Act number 11479 or the Anti-Terrorism Act of 2020.
Appearances?
May I request the 7 presenting lawyers for the petitioners to be followed by the counsel for the respondents and the amicus curiae to make your respective appearances.
Your Honors, Edsel Silagman, same appearance for the petition in GR number 252579. Thank you, Your Honors.
Your Honors, Neri Colmenares, same appearance, Your Honor, for the petitioners in petition GR number 252903, Your Honors. Thank you.
Good afternoon, Your Honor. Attorney Darwin Angeles respectfully entering his appearance for petitioners in GR number 252736. Thank you, Your Honor.
Good afternoon, Your Honors. Attorney Theodore Te for the Free Legal Assistance Group, entering appearance for petitioners in 252741.
Good afternoon, Your Honors. Attorney Evelyn Ursua, respectfully appearing for the petitioners in GR number 252747.
Good afternoon, Your Honor. Assalamu alaikum. Respectfully appearing for GR 252759. Attorney Baltuas Lukman is here with me, Your Honor. We are ready.
Good afternoon, Your Honors. I am Jose Anselmo I. Cadiz, respectfully appearing for the Integrated Bar of the Philippines and its Board of Governors in GR 253124, Your Honors. Ready, Your Honors. Thank you.
For the respondents, walang audio.
Walang audio. Okay. Your Honors, for the respondent, ASG Marisa de la Cruz Galandines, ASG Rex Bernardo Pascual, ASG Raymond Rigodon, ASG Diane De Vera, Solicitor Eduardo Pokis, Solicitor Dominic Clavano, and the Solicitor General Jose Calida, Your Honors. We are ready, Your Honors.
Are the amici around? Okay. This afternoon session is for the presentation of respondents' arguments. The Solicitor General is given 45 minutes to make his opening statement. Thereafter, interpellation by the justices shall proceed. After the interpellation of the justices, the court will hear the amici curiae. Before proceeding, Justice Mario Lopez has requested time to address the petitioners. Justice Mario, please proceed.
Thank you, Mr. Chief Justice. I just want to clarify last hearing because I want to explain something which were not duly taken up. Since the matter of terrorism and other crimes, I would like to point out the dichotomy of this crime of terrorism. Invariably, Your Honor, Mr. Chief Justice, invariably, all crimes are intended for prevention, deterrence, retribution, and rehabilitation. All crimes. While in terrorism, in addition to all of these purposes, there is the theory of self-defense, which is espoused by this kind of crime. Now, because of this, there may be a possible qualification of the application of our jurisprudence, particularly the case of Southern Hemisphere vis-a-vis the case of Disini. In other words, insofar as terrorism is concerned, so far, if we have to classify this terrorism as self-defense, then I would say Southern Hemisphere will apply and not Disini. That is why I am asking this opportunity, Mr. Chief Justice, so that the petitioners could clarify through their memorandum if ever this matter will come out. And I think that is very important so as to delineate what really is the jurisprudence properly applicable in this case. Thank you, Mr. Chief Justice.
Mr. Solicitor General Jose P. Calida, please proceed with your opening statement. No audio from the Office of the Solicitor General.
Pwede na? Good afternoon, Your Honors. Terrorism must be outlawed in all civilized nations, not explained or rationalized, but fought on and eradicated. Nothing will justify the murder of innocent people and helpless children. I just quoted Elie Wiesel, Nobel laureate, professor, political activist, and Holocaust survivor. Your Honors, not long ago, a fraction of a second was all it took for the terrorists to detonate the bombs that killed 23 innocent Filipinos in Jolo Cathedral. And just recently, at least 15 more in Jolo. Add to this hundreds more of wounded victims and bereaved families whose lives are forever marred by terror. In a blink of an eye, the terrorists created fear to intimidate our people. Our nation is outraged. Every second counts in the fight against terrorism. A fleeting moment could spell the difference between lives lost and lives saved. My mission as Solicitor General is to see to it that the Anti-Terrorism Act will not be derailed by 37 frivolous lawsuits, I respectfully invite your honors to help our nation's battle against terrorism. Let us start by junking the petitions. Outright dismissal is the only choice available in this case because first, there are other parties not before this court with direct and specific interests. Examples are Japer Gurong and Junior Ramos, who are facing criminal cases before the RTC of Olongapo. Second, the Anti-Terrorism Act presents a political question. And third, the nullification of the Anti-Terrorism Act would compromise our international economic commitments and endanger our economic survival as a nation. Let me elaborate, Your Honors. One, supervening events warrant the outright dismissal of the petitions. Let's look at the first ground of dismissal. There are already cases involving implementation of the Anti-Terrorism Act. Two ATAs, namely Junior Ramos and Japer Gurong, are facing cases before the Regional Trial Court of Olongapo City, and another 3 cases against 3 individuals in Negros Occidental. This was stated by 23 petitioners in their joint motion dated November 26, 2020, as well by the petitioners in Bayan in their compliance and manifestation dated November 18, 2020. Furthermore, Your Honors, 4 criminal cases have been filed in Holo Sulu against 13 individuals and several John and Peter Does for violation of Sections 4A and 4D of the Anti-Terrorism Act. The accused in these cases, led by Mudzimar Mundi Sawadjaan, are indicted for the August 24, 2020 Holo bombings. Another case for violation of Section 4D is pending before the RTC of Gubat, Sorsogon. Recently, the ATC applied Section 25 of the Anti-Terrorism Act and designated the Communist Party of the Philippines, New People's Army, as terrorists organization. In the case of Southern Hemisphere versus ATC, this honorable court ruled, and I quote, "More important, there are other parties not before the court with direct and specific interests in the question being raised. Of recent development is the filing of the first case of proscription under Section 17 of RA 937-2 by the Department of Justice before the Basilan Regional Trial Court against the Abu Sayyaf group. Petitioner organizations do not in the least allege any link to the Abu Sayyaf group," unquote. These individuals and groups now stand to sustain direct and personal injury as a consequence of the implementation of the law. In stark contrast, herein petitioners cannot even make the same claim. It is the duty of petitioners to demonstrate actual case and controversy worthy of judicial resolution. Despite the braggadocio of the petitioners, they did not do it. The persons now facing charges for violation of Anti-Terrorism Act are not before this honorable court. Instead, they are now litigating their cases before the regional trial courts. Ergo, any resolution in this case would be purely academic and hypothetical, a clear waste of this honorable court's time and resources. Number 2, political questions are beyond the reach of judicial scrutiny. As to the second ground for outright dismissal, Congress, in its wisdom, passed a new Anti-Terrorism Act. Political question is the reason behind this enactment. The doctrine of separation of powers barricades it from judicial scrutiny. The determination on this matter exclusively rests upon Congress. Due deference from the courts, including this honorable court, is expected. In Garcia versus Drilon, this honorable court categorically stated that the exercise of discretion with respect to what motivates Congress to enact law and how it wishes to accomplish its intentions are matters solely within the prerogative which the judiciary should not supersede. The Global Terrorism Index of 2018 ranked the Philippines as the 10th country most negatively impacted by terrorism. We are grouped with countries such as Iraq, Afghanistan, Nigeria, Syria, Pakistan, and Somalia. In fact, our country experienced the highest negative impact from the terrorism among states in the Asia-Pacific region. Meanwhile, the House of Representatives noted that the Philippines rose to 9th place in the 2019 Global Terrorism Index. Both houses of Congress expressed the same sentiments that a stronger, proactive, and responsive law is urgently needed. The Anti-Terrorism Act was passed to combat terrorism, effectively shield Filipinos from terrorists' brutal attacks, and prevent the country from becoming a haven for extremist groups. According to the 2020 Global Terrorism Index, the Philippines still retains its dubious distinction as the only Southeast Asian country to be ranked in the 10 countries most impacted by terrorism. Undeniably, terrorism has devastating economic, social, and security consequences. Thus, well-planned and calculated policies were adopted by the political departments of the government to eradicate terrorism. Those who connive with the implement abominable atrocities against the Filipino nation must be put behind bars. Our lawmakers enacted the Anti-Terrorism Act primarily for the peace and security of our country. The ATA protects the economy, the economic and financial security of Filipinos against the adverse effects of gray listing, or worse, blacklisting by the Financial Action Task Force, or FATF. Questions on the propriety and timelessness of the law's enactment as raised by petitioners are purely political questions, and as such, beyond the ambit of this honorable court's power of judicial review. Number 3, the ATA is essential to the Philippines' compliance to international obligations. Concerning the third ground for outright dismissal, the Congress stressed the need for Anti-Terrorism Act because the FATF set a deadline for the enactment of an anti-terrorism statute. If our country fails to comply, the Philippines will be in danger of being included in the high-risk and non-cooperative jurisdictions of the global anti-money laundering watchdog. Such a law, the Philippines will be treated, without such a law, the Philippines will be treated as a leper. FATF will see to it that either blacklist us or put us on gray list. The framers of the Anti-Terrorism Act were guided and goaded by our existing international obligations when they crafted its provisions. The enactment of the Anti-Terrorism Act made us compliant with our obligations under the United Nations Security Council Resolution number 1373 and the International Convention for the Suppression of the Financing of Terrorism. As a member of the United Nations, the Philippines should fulfill in good faith the obligations it assumed in accordance with the UN Charter and should agree to accept and carry out the decisions of the UNSC. Under UNSCR number 1373, member states such as the Philippines are mandated to prohibit their nationals from making funds, financial services, or economic resources available to those who commit terrorist acts. The latest mutual evaluation report of the FATF rated the Philippines as only compliant to UNSCR number 1373. The UNSC found Philippines' efforts in preventing terrorist financing as grossly deficient. Gray listing reduces investor and lending confidence. It may also result to limited access to banking and financial services. Millions of OFWs and their families will be severely affected by the higher cost of remittances, which reduce the amount of their support. Philippine banks will also increase loan interest to borrowers. With higher interest rates, the effect will trickle down to businesses of the country, which will have higher costs of operations. Clearly, gray listing would seriously affect the country's international trade, remittances, and humanitarian financial flows that support the country's economic growth and development. The Anti-Terrorism Act, most especially Sections 25 and 36 thereof, serves as a lifeline to the continued strength of the Philippine financial system. If the country fails to adopt a legal framework compliant with our international obligations, gray listing is not a risk, but an inevitability. Petitions are formally defective. While we could have ended our presentation in the foregoing grounds for outright dismissal, we notice that the petitions are insufficient in form and substance. The revised rules of civil procedure states, Section 3, dismissal due to fault of plaintiff. If for no justifiable cause, the plaintiff fails to comply with these rules or any order of the court, the complaint may be dismissed upon the motion of the defendant or upon the court's own motion. This dismissal shall have the effect of an adjudication upon the merits unless otherwise declared by the court. In Abogado versus DENR, this court ruled, and I quote, as with the procedure in special civil actions for certiorari, prohibition, and mandamus, this procedure also requires that the petition should be sufficient in form and substance before a court can take further action. Failure to comply may be the basis for the petition's outright dismissal, unquote. All 37 petitions must be dismissed due to formal violations and non-compliance with the resolution of this court. 1, the following petitions lack verification and certification of non-forum shopping or detached defective ones. Hendy Abendan of the Center for Youth Participation and Development Initiatives et al., Dr. Ramon Guillermo et al., Harun Al-Rashid Alonto Lukman Jr. et al., Lagman et al., and Lawrence A. Yerbo. 2, the following petitions fail to state the required attestations found in Section 4, Rule 7 of the said rules. Center of Trade Human Rights, San Lakas, Federation of Free Workers et al., Alagmar Latif, Concerned Online Citizens et al., and Anak Mindanao Party List. 3. The following petitions has not to this day submitted special power of attorney to allow their counsel to represent their interest in this case. Longid et al. Number 4. The following petitions failed to number their paragraphs in their respective petitions, contrary to the directive of Section 2, Rule 7 of the Revised Rules of Court. Santa Maria et al., Algamar Latif, Hendy Abendan of Center for Youth Participation and Development Initiatives et al., Monsod et al., and Lawrence A. Yerbo. The petitions are riddled with procedural infirmities that warrant no less than dismissal. Number 5, petitioners have no locus standi to file the subject petitions. Not only the petitions suffer from formal defects, but these also fail to establish requisites for judicial review. Again, 37 petitions were filed assailing constitutionality of the Anti-Terrorism Act. In these consolidated cases, petitioners invoke their diverse capacities, hoping to justify and establish their legal standing that will merit the consideration of this honorable court. The principle of locus standi has long been settled. It calls for more than just a generalized grievance. It must be a personal and substantial interest whereby a person will incur direct injury due to the governmental act assailed. It should be material, not merely incidental. There should be a present substantial interest and not a mere expectancy or a future contingent, subordinate, or consequential interest. Majority of the petitioners invoked and repeated harp on the doctrine of transcendental importance to justify their obvious lack of direct and personal interest in their cases. Moreover, they violated outright the hierarchy of courts. In the absence of exact definition, jurisprudence provides the following as determinants of the application of the doctrine. Number 1, the character of the funds and other assets involved in the case. Number 2, the presence of a clear case of disregard to a constitutional and statutory prohibition by the public respondent agency or instrumentality of the government. And number 3, the lack of any other party with a more direct and specific interest in raising the questions being raised. There are now exists parties with more direct and specific interest in the very issues being raised before the Supreme Court than herein petitioners. To reiterate, criminal cases have been filed already against 2 ETAs at the Regional Trial Court of Olongapo City for violation of the Anti-Terrorism Act. Petitioners do not also allege any link to the 2 ETAs. This automatically divests petitioners the right to invoke the doctrine of transcendental importance, on which their whole theory on locus standi depends on. Unlike the ETAs who lost their liberty, the petitioners did not suffer any direct or indirect injury that will vest them with locus standi. Number 6, there exists no actual controversy in this case. Apart from the petitioner's lack of standing, there is also a complete absence of any actual justiciable controversy to be settled in this honorable court. Justice Leonen pointed out this fatal defect of the petitioners during the interpellation. An actual case of controversy is one which involves a conflict of legal rights and assertion of opposite legal claims susceptible of judicial resolution as distinguished from a hypothetical or abstract difference or dispute. Courts will decline to pass upon constitutional issues through advisory opinions, bereft as they are of authority to resolve hypothetical or moot questions. Similarly, petitioners' obscure allegations of future and contingent surveillance and red tagging, among others, are not credible threats of prosecution that would make the petitions as actual justiciable cases or controversies. Clearly, the present petitions grossly failed to show the existence of an actual case or controversy over which this honorable court may exercise its judicial power. Number 7, direct resort to this honorable court is unjustified. Another fatal flaw in the direct resort to this honorable court to challenge the Anti-Terrorism Act is the failure of petitioners to follow the doctrine of hierarchy of courts. Let me quote Amicus Curiae Justice Hardilesa, speaking for this court in Gius Samar versus DOTC, and I quote, "The doctrine of hierarchy of courts dictates that direct recourse to this court is allowed only to resolve questions of law, notwithstanding the invocation of paramount or transcendental importance of the action," unquote. This doctrine is not to be taken lightly. A petitioner has no unfettered discretion to compel this honorable court to jump over the hierarchy of courts. Therefore, the petitions must be dismissed. Number 8, this honorable court is not a trier of facts. Majority of the petitioners cited factual allegations relating to supposed red tagging, the truth or falsity of which are clearly doubtful. There is a question of fact when the doubt arises as to the truth or falsity of the alleged facts. It is well settled that this honorable court is not, and I repeat, not a trier of facts as provided for in Section 2, Rule 3 of this court's internal rules. We quote a portion from Gius Samar case penned by Amicus Curiae Justice Hardilesa, and I quote, "This court, however, is not a trier of fact. We cannot resolve these factual issues at the first instance," unquote. For raising questions of fact, the foregoing petitions should be dismissed. Number 9, a facial challenge against the ATA is improper. We shall now controvert pertinent issues raised in the advisory to assuage the fears of the public from those who demonize the Anti-Terrorism Act despite its noble intent to protect the public. A caveat on the petitioner's reliance of facial challenge. In Humambil versus Cafe, the policy of the courts is to avoid ruling on a constitutional question and to presume that the acts of the political departments are valid in the absence of a clear and unmistakable showing to the contrary. In Romualdez versus Comelec, this court ruled that under no case may penal statutes be subjected to a facial challenge and should not be declared unconstitutional for overbreadth and vagueness. This principle has been affirmed as good law by this court as recently as 2019 in Madrilejos versus Gatdula. Amicus Curiae Justice Hardilesa quoted Romualdez versus Comelec that facial challenge against a penal statute is at best amorphous and speculative, It would essentially force the court to consider third parties who are not before it. As emphasized by Justice Mario Lopez, never before anywhere has a facial challenge been mounted against a penal statute defining and punishing crimes against national security. The rule must stand. Constitutionality of the Anti-Terrorism Act may only be assailed in actual criminal trial. Number 10, the ATA is a valid exercise of the police power of the state. Several petitioners question the constitutionality of the ATA on the ground that the law does not satisfy the tests of a valid exercise of police power. They are wrong. In Zabal versus Duterte, this honorable court described police power as the inherent and plenary power of the state, which enables it to prohibit all things hurtful to the comfort, safety, and welfare of the society. The strict scrutiny test requires that a law, number one, is necessary to achieve a compelling state interest. And number two, it is the least restrictive means to protect such interest. On the first requirement, no less than the Constitution declared as principle the prime duty of the government to serve and protect the people and to secure the sovereignty of the state and the integrity of its national territory. The second requirement of strict scrutiny, the adoption of least restrictive means, has always been fully complied with. The Anti-Terrorism Act adopts narrowly drawn mechanisms to avoid conflict with constitutional rights. Since the Anti-Terrorism Act is a penal statute, the Congress meticulously puts safeguards in the Anti-Terrorism Act to avoid abuses. Among these are the prohibition against torture or coercion in investigation and interrogation, and the upholding of the constitutional rights of persons under custodial investigation. Moreover, the Anti-Terrorism Act assures that its implementers will not abuse their authority. ATA is replete with provisions that penalize abuses in its implementation. There are checks and balances in the law to make sure that grave abuse by the implementers will be penalized with imprisonment to deter exploitation of the law. Therefore, contrary to petitioners' argument, there is no undue restraint allowed by the Anti-Terrorism Act. It is crystal clear that the Anti-Terrorism Act is brimming with strong safeguards that will effectively prevent abuses in its implementation and protect persons under the custody of the law. The Anti-Terrorism Act is a result of studies and specific findings of the legislature on the serious threat of terrorism, domestic and international alike. The state cannot turn a blind eye on the practical realities brought by terrorism. On this note, the wisdom of the legislative decision to crush terrorism while giving justice to any person in interest should be abided. The honorable interest has upheld time and again. Individual liberties must give way to the compelling state interest. As eloquently stated by Justice Ami Lazaro Javier, the state has the right to protect itself. In this case, the far more overriding demands and requirements of the greater number is to live safely in peace instead of being perpetually paralyzed as a victim of terrorism. The full enjoyment of basic rights can only be achieved if there is freedom from fear. The Anti-Terrorism Act satisfies the test as to whether the law is a valid exercise of police power. Number 11, terrorism is a criminal conduct with specific intent. The definition of terrorism under Section 4 of the Anti-Terrorism Act is complete. It is neither vague nor impermissibly overbroad. Under Section 4 of the Anti-Terrorism Act, the crime of terrorism consists of two elements: the actus reus, or the overt act, and the mens rea, or the criminal intent. It identifies 5 distinct acts, 3 of which are intent-specific, which in order to qualify as terrorism must be intended to accomplish any of the following purposes: to intimidate general public and segment thereof, to seriously destabilize or destroy fundamental structures of the country, to create a public emergency, and seriously undermine public safety, as repeatedly echoed by Chief Justice Alexander Hesmundo and Justice Mario Lopez. To repeat, the law is clear. It is conduct coupled with specific interest which comprises the crime of terrorism. Number 12, the ATA maintains probable cause in warrantless arrest. There is nothing in the anti-terrorism that eradicates probable cause as the threshold in conducting valid warrantless arrest. It remains to be an ironclad rule. Moreover, the phrases suspected of and charged with are used in the law as antitheses of each other. This means that the phrase suspected of simply refers to someone who has not yet been charged with before a court for violation of the Anti-Terrorism Act. In other words, a suspect in ordinary parlance. The use of the word suspected in Section 29 does not wipe out the threshold of probable cause in warrantless arrest under the rules. Number 13, the ATA ensures lawful data acquisition and handling. Neither does the Anti-Terrorism Act violate the citizen's right to privacy. The law contains sufficient safeguards to ensure that data are lawfully acquired and properly handled. Section 18 requires that the written surveillance order to be granted by the Court of Appeals should contain 1, identity of the person to be surveilled; 2, identity of the law enforcement agent or military personnel judicially authorized to undertake surveillance activities; number 3, the offense or offenses committed or being committed or sought to be prevented; number 4, the length of time within which the authority shall be used or carried out. This accountability-driven system of checks and balances is noticeably absent in other countries' anti-terrorist legislation. In Canada, for one, only the ministerial authority issued by the Minister of National Defense is needed to green light any interception of private communications. Meanwhile, India's Information Technology Amendment Act of 2008 gives its government the sweeping power to tap all communications without any court order or warrant. Number 14, the ATA regulates conduct, not speech. Contrary to petitioner submissions, sections 4, 5, 6, 7, 8, and 9 of the Anti-Terrorism Act do not violate the freedom of speech, expression, and of the press. The Anti-Terrorism Act was enacted to protect individuals from terroristic attacks, to ensure respect for the right to life and the right to security of each citizen. The state is compelled to regulate the conduct of its citizens as they exercise their rights, and the same is absolutely different to the postulated suppression of free speech. A clear distinction between the regulation of conduct vis-a-vis regulation of speech has been explicitly defined in Southern Hemisphere versus ATC. Almost every commission of crime entails some mincing of words on the different part of the offender. Thus, utterances not elemental but inevitably incidental to the doing of the criminal act does not alter the intent of the law to punish socially harmful conduct, nor the essence of the whole act is conduct and not speech. When a person's speech directed to another person or group of persons is of a quality that is likely to engender violent conduct, that communication, though verbal, is not speech as a part of the dialogue. Such speech is more akin to, in nature, to conduct because it is more likely to provoke conduct than dialogue. Therefore, it may be restricted as fighting words without regard to any message being communicated. The anti-terrorism penalizes terrorism whether committed through acts or through written or verbal communications. Specifically, terrorism as defined in Section 4 is clear and unambiguous. So are Sections 5, 6, 7, 8, and 9. They penalize conduct and fraudulent advocacy, inviting imminent lawless action and danger to national security with the apparent intent to incite people to support or commit terrorism. Notably, the prohibitions under this section fall within the same class of crimes already punished in the revised penal code as shown in this slide. All told, sections 4, 5, 6, 7, 8, and 9 of the Anti-Terrorism Act do not violate the freedom of speech, expression, and of the press. When a speaker's word do not contribute to dialogue or the expression of ideas, but are instead intended to provoke harmful conduct, they have no value as instrument of speech. Number 15, the ATA does not contravene the right to speedy trial and disposition of cases. Section 29 of the ATA does not violate a person's right to speedy trial and speedy disposition of cases. The petitioner should know that the right to speedy trial only attaches at the start of the trial and not prior thereto. This right, therefore, does not find application during the period of detention under Section 29 of the Act. Petitioners should be reminded that the right to speedy disposition of cases is a relative and flexible concept, and in no way can a mathematical reckoning of the time be considered as an inordinate delay. The peculiarity surrounding the crime of terrorism clearly justifies this period of detention. Number 16, the ATA's power are purely executive in nature. Petitioner should know that the Anti-Terrorist Council's written authority mentions Section 29 of the Anti-Terrorism Act is not a judicial warrant of arrest. Section 29 honors the inflexible truth that the issuance of a warrant of arrest remains to be an exclusive judicial process. Section 45 of the law states, nothing herein shall be interpreted to empower the ATC to exercise any judicial or quasi-judicial power of authority. Section 25 on designation is essentially an identification of a person or a group as being involved in terrorist acts. Unfortunately, petitioners misconstrue designation as a sweeping grant of prosecutorial, legislative, and judicial powers to the ATC. Nothing in the ATA empowers the ATC to file information or issue an arrest warrant. Rather, designation is an administrative and executive function of the Anti-Terrorism Council to facilitate the imposition of financial sanctions on terrorists. Designation plays a crucial role in the issuance of a freeze order by the Anti-Money Laundering Council to prevent terrorists from accessing funds. The only participation of the ATC in the freezing of assets is sending a request to the Anti-Money Laundering Council, which is not an automatic deprivation of the designee's property. Next, designation does not inflict punishment ex post facto. based on the adoption of the United Nations Security Council consolidated list and other requests for designation. Section 55 of the Anti-Terrorism Act explicitly provides a prospective application. Therefore, the anti-terrorism only imposes a penalty of acts or omissions committed after its effectivity. Petitioners are mistaken in assailing the adoption of the consolidated list, which includes all individuals and entities from across the globe that are involved in terrorism and are subject to measures imposed by the Security Council. Reference to consolidated list complies with the requirements of a valid delegation of a legislative power of the ATC. First, the ATA is complete. Second, the ATA defines legislative policy, which is to protect life, liberty, and property from terrorism. The ATC does not have the sole arbitrary discretion to determine who the terrorists are and what acts constitutes terrorism. Why? Because it is guided by the standard of probable cause. Reasonable ground of suspicion supported by circumstances warranting a cautious person to believe that the proposed designee meets the requirements for designation. This is further limited by explicit reference to offenses found in sections 4 to 12 of the Anti-Terrorism Act. Hence, the ATC cannot designate on mere suspicion, contrary to petitioners' unfounded fears. Number 17, the government is not the enemy. Recently in Oriental Mindoro, the CPP-NPA's plans to terrorize the citizenry, harass local law enforcement, and set critical infrastructure ablaze in time for its 52nd anniversary were foiled. Let us credit the efforts of the AFP's 4th Battalion, Scorpion Battalion. Our brave men and women in uniform were able to recover high-powered firearms, explosives, and ammunition, as well as documents outlining the NPA's dastardly plans. It is no secret that the CPA-NPA always resort to acts of terror in its bid to seize control of the government through armed struggle. No price too steep, no institution too sacred. Even going so far as to recruit children in their misguided cause. You can see them in the picture. On March 30, 2021, less than a month ago, PNP contingent raided a CPP-NPA armory at Santa Rosa, Laguna. Like in Mindoro, the police officers too found a cache of high-powered firearms and explosives, which included improvised anti-personnel and claymore mines. Likewise discovered in the armory were subversive documents, streamers, campaign paraphernalia of Congressman Colmenares, Bayan Muna, and Gabriela, and training materials on advanced revolutionary warfare. More recently still, on April 16, 2021, the 110 Brigade, Infantry Brigade, encountered members of the Abu Sayyaf Group. The Abu Sayyaf Group engaged the Philippine Army in a fair fight in Patikul, Sulu. Our armed forces prevailed and crippled the reign of terror by trained bomb maker Abu Katab Jundula, Abu Sayyaf fighter alias Akram, an Egyptian volunteer suicide bomber alias Yusuf, who is the son of Reda Muhammad Mahmoud, a suicide bomber in an army base in Sulu in 2019. Katab and Yusuf are under Muzimar Mundi Sawadjaan, who is behind the twin suicide bombings in Jolo in August 2020, as well as the Jolo Cathedral bombing in January 2019. Your Honors, petitioners have never spoken out against the recent atrocities committed by terrorists against our people. If they have never taken a stand on these acts, and if silent is complicity, there can be only one inescapable conclusion. Like any other law that has implications on individual rights, the Anti-Terrorism Act has been unfairly stigmatized as a mere legal ruse to quell oppositions against the current administration. This is a monstrous lie. The Anti-Terrorism Act is not an instrument of oppression, neither is it a tool to suppress vibrance of our democracy. No, it is an embodiment of the state's policy to protect life, liberty, and property from terrorism, a commitment to peace in our day and future of our children. In the words of our President Rodrigo Roa Duterte, and I quote him, "For the law-abiding citizens of this country, I am addressing you with all sincerity. Huwag ho kayong matakot kung hindi ka terorista." Thank you, Your Honors. Incidentally, Your Honors,
Thank you, Mr. Solicitor General.
for purposes of interpellation, Your Honors, we have filed a manifestation and motion last January 28, 2021, in compliance with the Honorable Court's advisory dated January 5, 2021. We have divided our chores, Your Honors. The Solicitor General handled the opening statement, and two of his Assistant Solicitor Generals, namely Reyna Godon and Marisa de la Cruz Galandines, will answer questions on the opening statement and any questions on the Bill of Rights and other provisions of the Constitution, respectively. Thank you, Your Honors.
Justice Rory.
Good afternoon, colleagues, petitioners, counsels, Solicitor General and his assistant. So I will begin first the interpellation. Can we have Associate Solicitor General de la Cruz Galindes? No audio? Meron?
Can hear you, Justice Rory.
Good afternoon, Your Honor. Good afternoon, Your Honor.
Good afternoon. You argue that petitioners have no standing to sue. How do you reconcile this with the fact that all petitioners are alleging that this case involves constitutional issues which are of transcendental importance and paramount public interest?
Your
Did
Honor.
you hear me?
Yes, Your Honor. Yes, Your Honor.
Can you answer it?
Yes, Your Honor. All petitions have not been able to satisfactorily show the attendance of all known exceptions to the principle of judicial hierarchy, particularly the transcendental importance of this case, the presence of a constitutional issue and its novelty.
The petitioners are alleging that there are several constitutional issues in this case, like infringement of freedom of speech, freedom of religion, freedom of association. Are these not basic constitutional issues that need to be resolved in this case?
Your Honor, it is our submission that these are not to be resolved in this case, Your Honor. These are mere motherhood statements, and petitioners have not shown actual actual circumstances that would apply to them. The Supreme Court, Your Honor, is not a trier of facts. The alleged facts are the circumstances of the encounter. The alleged facts, the petitioners must prove the alleged facts and must follow the doctrine of hierarchy of courts. For the Supreme Court is not a trier of facts, Your Honor.
Okay, we're aware that there are several cases filed against several people and now pending with the trial court. Do you think the constitutional issues involved in this case will be decided by the regional trial courts?
It is our submission, Your Honor, that the constitutionality of the ATA would be best addressed in the cases filed before the regional trial courts.
Why? Why should it be addressed by the regional trial court? Is the regional trial court not only to determine whether the accused committed the act or not, but will not go beyond the constitutional issues raised in these petitions?
Your Honor, please, it is our submission that the constitutional issues raised by petitioners are better addressed by the regional trial court as enunciated in the leading case of Gio Samar. We submit that the case of Gio Samar is applicable in the present cases.
You are only mixing questions of fact and constitutional issues. The Office of the Solicitor General is the People's Tribune, and you have been appearing in many criminal cases. Have you come across even for once that a constitutional issue is resolved in a criminal case?
Yes, Your Honor.
Have you attended to a criminal case wherein a basic constitutional issue of a violation of freedom of religion, freedom of speech, freedom of association has been considered and ruled upon by the trial court?
Yes, Your Honor. The Office of the Solicitor General did attend cases of that nature before the regional trial court.
Can you give us, say, a resolution of the court or a decision of that court touching upon not only the criminal liability of the accused, but touching more importantly on the constitutional aspect that I have been pointing out?
Your Honor, I could not speak of a particular case, but I would remember the case of Senator De Lima pending before the Regional Trial Court of Muntinlupa, where the constitutionality of 9165 was one of the sections was an issue before the Regional Trial Court of Muntinlupa.
But it has not yet been resolved.
Yes,
so it has not yet been resolved by the trial court.
Yes, Your Honor, but the constitutionality of the drugs law has been raised, Your Honor.
Has been raised.
Yes, Your Honor.
Okay, let's go to another point. So you cannot point to a court decision either by the regional trial court on original case or even by the Court of Appeals on review of that original case touching upon the constitutionality of a certain penal law.
Not a specific case at this point, Your Honor, but we will surely include that in our memorandum, Your Honor. Because,
Thank you.
Your Honor, that we have indeed handled that kind of case, Your Honor.
Okay, let's go to another question. You argue as held in the case of Southern Hemisphere versus Anti-Terrorism Council that the present petition should be dismissed on the ground that the petitioners face no credible threat of prosecution. Do you mean to say that each one of the petitioners must be charged first criminally before they can seek the Supreme Court for relief?
Yes, that is our submission, Your Honor.
Notwithstanding the fact that they're raising basic constitutional issues, basic violations of basic rights of individuals like freedom of speech, freedom of association, freedom of religion.
Yes, Your Honor.
So each one of them must be first charged before the regional trial court.
Yes, Your Honor. Locus standi, Your Honor. They must have a personal and substantive interest in the case, Your Honor.
Okay. Can you explain the main difference between the definition of terrorism under the Human Security Act and under the present Anti-Terrorism Act?
Your Honor, can I ask my colleague to answer that question, Your Honor?
Okay.
Good afternoon, Your Honor. The basic difference is that,
Can you please introduce yourself first?
sorry, Your Honor, I'm Assistant Solicitor General Raymond Rigodon.
So you are ASG Rigodon. Okay. Sige po.
The basic difference between the definition of terrorism under the Human Security Act and the Anti-Terrorism Act is that in the Human Security Act, the law enumerates predicate crimes which must be established together with the motive for the commission of these predicate crimes. In contrast, the Anti-Terrorism Act did away with these predicate crimes, and in lieu thereof, it enumerates certain intent-specific acts with the exceptions of Section 4D and 4E, which, when committed for the specified purposes, as mentioned in the second paragraph of Section 4, constitutes the crime of terrorism.
So you are in effect saying that under the Human Security Act, there are predicate crimes involved and
Yes.
need be committed before being charged under the provisions of the Human Security Act then.
Yes, Your Honor.
So you will agree with me that the definition under the current law is more general compared to the Human Security Act, which required commission of predicate crimes. Can we not say that this more general definition now puts petitioner under credible threat of prosecution, since they need not commit specific predicate crimes before they can be punished under the law, the new law, the ATA law?
I don't think so, Your Honor, because the definition of the crime of terrorism under Section 4 is delimited by the presence of specific intent and purpose, Your Honor. If these two are missing, then there is no crime of terrorism under Section 4.
So it's act, as you say, it's act plus
Purpose, Your Honor.
plus
Purpose.
nature. It's only act and plus purpose.
Yes, Your Honor.
Okay. Parang may kulang ata yun. So I will continue questioning you, Assistant Solicitor General Rigodon, because this, I think, is your assignment. Why does the government say that facial challenge is not proper in this case?
Because the Anti-Terrorism Act, Your Honor, prescribes conduct and not speech, and because of this, and also it is a penal law, and therefore, as a facial challenge should not be allowed, Your Honor.
It's a general rule that penal law is not subject to facial challenge. Okay.
Yes, Your Honor.
But how do you reconcile this with the court's ruling in Bong versus Ochoa, stating that facial challenges also cover statutes not only regulating free speech, but also those involving other fundamental rights?
If I remember correctly, Your Honor, in the case I think Bong expanded the grounds for generally the reproductive law is not a penal law, but it contains certain provisions that imposes penalties for certain non-compliance with its provisions, Your Honor. So those provisions, I think the Supreme Court allowed the facial challenge.
Okay, you can better explain your arguments in your memorandum because we are not clear upon that.
Yes, Your Honor.
And you also argue that the exception in the Dicini case does not apply because the novelties of cyberspace. However, petitioners argue that their cyber rights are also infringed. Can we not say that the particularities in the Dicini case are also present in this case?
So, Your Honor, because what is clearly prohibited in the ATA is conduct, Your Honor, and not speech.
Are you sure of that?
Yes, Your Honor. In the Dicini case, there are provisions there which regulate, for instance, the provision prohibiting the commercial solicitation, or as commonly known as spams, which is a form of commercial speech, Your Honor. And those with respect to the crime of cyber libel and abetting cyber libel, Your Honor, which pertain to speech, Your Honor.
And cyber libel is not a protected speech, right?
Yes, Your Honor.
In facial challenge, is this court limited to using the void for vagueness and overbreadth doctrines, or there are other tests that can be applied by the court?
Based on jurisprudence, Your Honor, these are the two grounds utilized for mounting a facial challenge, Your Honor.
The court cannot use any other tests?
I said that the court cannot use other tests because these other tests would only be applicable in an as-applied challenge, Your Honor.
Can the court not use rational basis test, intermediate scrutiny test, or strict scrutiny test?
I believe, Your Honor, that these tests would be used in weighing the whether or not the legislation, the interest involved in the legislation is outweighs the civil or political liberties being asserted, Your Honor.
So in a facial challenge, it's the position of the government that the only test that the Supreme Court or the courts can use are void for vagueness and overbreadth doctrines.
Yes, Your Honor.
Wait. Are you aware that the Imbong case adopted the strict scrutiny test? Sige, you can review and you can reread the case and tell to the court if any other test has been used. Not now. Not now.
We can in the memorandum, Your Honor.
Next question. Assuming that Section 4 is struck down as unconstitutional, do you think the entire law should be struck down as well?
Our position, Your Honor, is that because of the separability clause, the rest of the provisions will survive, Your Honor.
So, assuming that Section 4 is struck down, the rest of the law will remain valid.
Yes, Your Honor.
Is that not the law anchored on Section 4? That if Section 4 is, that's the main spirit and the main body of the law. And therefore, if that is struck down, nothing will live after that.
With due respect, we maintain our position because
the other acts punishable, proposal to commit terrorism, what's that? Those stages of commission are related to the commission of terrorism. So it's the position of the government that if Section 4 is struck down, the remaining of the law will still survive.
Yes.
The Solicitor General said that our compliance with international obligation with respect to fight on terrorism has been only partially compliant. What more does the government have to do to upgrade this status? Do you know?
I believe, Your Honor, that our position as articulated in the consolidated comment is that if the ATA law will be declared, in the remote possibility that the ATA law will be declared unconstitutional, there is a possibility that the government will be gray listed, Your Honor.
No, what I'm saying is earlier the Solicitor General said that our compliance is only partial. What the court would like to know is what must the government do to upgrade our status to fully comply with our international obligation to fight terrorism?
Your Honor, we request our client agency, the Anti-Money Laundering Council, to shed light on that, to further shed light on that, Your Honor.
Are they ready to answer now? Or you might include that in the memorandum that the court will ask of you to file after this argument.
The representatives from the AMLC is in our office right now, Your Honor. We're checking if they can respond to your question.
Is it only related to the anti-money laundering business or in any other commitment that the government must have to do to upgrade its status from partially compliant with our international obligation to at least upgrade it a little higher? Is it only in the anti-money laundering law? Okay. So you're not ready to answer that?
The AMLC is here right now, Your Honor. They can answer. If they will be allowed.
Chief, can we allow?
The director of AMLC is here, is with me, Your Honor. Director Rosella, Your Honor, if he may be allowed to speak, Your Honor, in response to your question.
Can he not just whisper the answer to you? Can you have a 2-minute conference with him? Anyway, the question of the court is very simple. How do we upgrade our status?
Can I confer for a minute? For a minute, Your Honor.
Yes, please. Yes, please.
But it is only to be the father has to confirm the upgrade. The financial action task force. So, because of the ATA, as it is right now, we are fully compliant.
Because of the, among others, the passage of the
So, pagka po na declare unconstitutional, balik tayo sa part.
Your Honor, I was informed that by Director Rosella that we have already been upgraded and we're just waiting for official confirmation from the FATF, Your Honor. Walang sound. No sound, Your Honor.
So it is only with respect to our compliance with the anti-money laundering laws.
Um, um, the upgrading has also to do with the passage of the Anti-Terrorism Act, Your Honor.
Okay. Let's go to another question. What must the prosecution prove to convict someone under Section 4 of the ATA?
There must be an overt act. The commission, any of those mentioned in the overt act mentioned in Section 4A to 4E, Your Honor.
Okay.
And the prosecution must show that the overt act is accompanied by the specific intent mentioned in Section 4.
Okay.
And in addition, the prosecution must also show that by its nature and context, these overt acts were committed for the unlawful purposes mentioned in the
law.
In the law, Your Honor.
Okay. So that's very, very clear. Consider this example, huh? A man was carrying a grenade around Quiapo Church while a mass was being held. A bystander saw he was carrying and shouted, "Granada!" And this led to 100 of people going into panic. He was then apprehended by the police. Now, based on the facts presented, can the man be prosecuted under Section 4? Or can you cite a fact that proves that the purpose is to commit terrorism and the nature and context of such purpose? Simply a man holding a grenade.
Based on Your Honor on the example, that is not sufficient to charge him with terrorism because there is no evidence as to what is his intent in carrying that grenade. And secondly, there is also no evidence as to the purpose for carrying that grenade, Your Honor.
Next question. If that guy who wanted really to throw the grenade just to kill his enemies, whom he see there attending mass in Quiapo Church, will he be punished under the anti-terrorism law? Or can he be punished under other special laws?
I think based on the example, Your Honor, you can only be punished for either murder or homicide, Your Honor, because it is not clear that the purpose is included in those which the law prohibits under the second paragraph of Section 4, Your Honor.
Okay, since he was arrested in flagrante delicto, can the officer or the police officer or the government agent distinguish between, can he distinguish between terrorism and possession of hand grenade as just in a specific case? At that point in time that he was arrested, can the police officer distinguish?
No, Your Honor, because intent is a mental state of mind, and therefore, unless the police can secure as personal knowledge on what the specific intent of that person at that precise moment in time, it would not be possible to charge him or to apprehend him for violation of the terrorism law, Your Honor.
At most, initially,
Legal possession of explosive.
maybe if he threw the bomb or the grenade, murder or whatever, common crimes.
Yes, Your Honor.
So you are in effect admitting that from the example given, the enforcement officers are now given such a wide discretion in apprehending the suspects based only on his own perception of terrorism?
Because the law requires, Your Honor, under a warrantless arrest, that the apprehending officer must have personal knowledge. Therefore,
Okay.
if that if that police officer does not have personal knowledge on the intent of that person or the purpose of that person in carrying that grenade, then he cannot validly arrest him without a warrant for violation of Section 4 of the ATA, Your Honor.
You
It
should-
can only apprehend him for violation of common crimes, Your Honor.
Common crimes. Do you know the multiple safeguards in the Human Security Act which have now been deleted from the Anti-Terrorism Act?
The most notable, Your Honor, is the removal of the provision awarding the amount of 500,000 pesos to an accused who is acquitted of a charge of terrorism under the Human Security Act, Your Honor.
Yun lang ba yun?
Because the ATA, as far as I recall, Your Honor, also contains numerable safeguards against the improper implementation.
So you were not able to compare completely the differentiation between the Human Security Act and the ATA. There are several safeguards in the Human Security Act which were deleted in the ATA. Like, for example, no other effective means readily available for acquiring the evidence before surveillance can be allowed. The duty to inform the person being surveilled of the activities being undertaken by the law enforcement agent. That the warrantless arrest of suspects must result from surveillance and examination of bank deposits. And the requirement to present the arrested person immediately before a judge prior to his detention. So these are the safeguards that were removed by the ATA law. So you're not aware of this, no? Are you aware of the hurdles that were faced by the government in enforcing the Human Security Act, that it need be amended by the ATA?
Based on the Senate deliberations, Your Honor, the number the prosecution and law enforcers found it difficult to establish a case for violation of terrorism under the ATA because first they have
under the Human Security Act.
Yes, Your Honor, because
first
because they have to establish all the elements of the predicate crimes, and in addition to establishing all these elements, they have to prove the motive behind the commission of these predicate crimes, Your Honor. Unlike the in comparison to the ATA, Your Honor, instead of predicate crime, as I mentioned earlier, the law enumerates acts, Your Honor.
Hindi ba mas madali na nakikita mo that there was a bomb thrown, people were murdered, people were killed because in pursuit of terrorism, rather than a set of acts to be done as mentioned in the law?
As noted by, I think, Justice Mario Lopez or Chief Justice Quesmundo, the way that the definition of terrorism is structured under the ATA, it is more flexible because it can respond to evolving methods that will be adopted by terrorists.
By terrorists.
Yes, sir. For example, the one of the predicate crimes in the HSA is murder. Therefore, if what has been committed is homicide, then it cannot qualify under the definition of terrorism under the Human Security Act. But under the ATA, if the intent and purpose of the crime is homicide, that person can be charged under the Anti-Terrorism Act.
The provision of Section 4 states, terrorism shall not include advocacy, protest, dissent, stoppage of work, and so on, which are not intended to cause death or serious physical harm to a person, to endanger a person's life, or to create a serious risk to public safety. Does this effectively put the burden of evidence on the accused to prove that the exercise of his rights is legitimate?
Yes. Yes, Your Honor, because this proviso is a matter of defense, Your Honor.
It's a matter of an exception.
Yes, once the prosecution has established the commission of the acts mentioned in the first paragraph, and also has also established the purpose, then it is incumbent upon the accused to raise as a defense that is merely exercising his civil or political
rights. Okay. Let's go back to another example. A riot broke out during the 1986 EDSA revolution and resulted to death of some individuals. Does this qualify as terrorism under Section 4 of the law? Nagka-riot nun sa EDSA, may namatay. Is this terrorism?
Unless the riot, Your Honor, was intentionally done to harm other people or to cause death or to cause serious physical injury, and the purpose of causing that riot is to sow fear among those assembled in EDSA, it will not be terrorism, Your Honor.
Were you aware already of that event, ASG?
I was in high school, Your Honor, when EDSA
when EDSA happened. But there was no ruckus, there was no planned takeover of government at the time.
When I visited the place, when I had the chance, Your Honor, it was relatively peaceful, Your Honor. The assembly there.
It was only for the purpose of maybe the people are gathering then to prevent the army from shooting some people there, from inflicting harm to the rebels, but not really to overtake the government or overrun the government.
That's probable.
How about what happened in capital of the United States? Would you consider that? The January 6th incident after the loss of Trump, would you consider that as terrorism under our law?
It may be possibly considered as terrorism, Your Honor.
Because
if the person who incited others, the intent is to cause extensive interference to critical infrastructure or to cause damage, and the purpose is to sow fear among the senators or congressmen present there at that time, and other officers at the Capitol, Your Honor.
in your appreciation, what was the reason why people gathered in the Capitol on January 6th? Your
I think
assessment.
I have not really familiarized myself with that,
You did not view it.
Your Honor. I just read a portion of it in the news media.
So after I gave you the example, there is a difference between the exercise of civil and political rights intended to cause death, harm, endanger person's life, or create risk to public safety, and the exercise of rights which merely resulted into those things.
Yes, Your Honor.
So what is important is your intention
Yes, Your
plus
Honor.
the result.
Intention and purpose, Your Honor.
Yeah, the result, purpose, intention, and purpose. So that if
Yes,
the
sir.
result happened to be like this, but the intention was not, there is no terrorism.
Yes, Your Honor.
But how can you say that there is no terrorism or there is terrorism, or the act done is a terroristic act, or the act done is not an act of terrorism?
What controls, Your Honor, is the intent of the individual committing the act, Your Honor.
You know, the intent is in the mind. How can you
Um,
extract intent from the mind of a person?
Perhaps if there is through the overt act, Your Honor, we can perhaps apply by analogy the principles developed by the Supreme Court with respect to crimes under the revised penal code, where the intent was gathered from the overt acts committed by the accused.
Okay. Siyempre, there was Marawi 6, no? What are the charges leveled against those people, if you know?
I think based on the martial law cases, rebellion, Your Honor.
Rebellion.
Yes, Your Honor.
So plainly rebellion.
Rebellion ba? Rebellion. Yes, Your Honor. As far as we know, rebellion.
So that if it happened after the passage of the law, they will be charged of rebellion only?
It will depend on the acts committed, Your Honor.
Nakita na nga natin the results of the acts in the Marawi siege. How will they be charged if these acts were committed after the passage of the law? Will it still be rebellion?
They can be prosecuted for terrorism, Your Honor.
Terrorism. Does the ATA define the term inciting?
No, Your Honor.
No. Can we now take the definition and enumeration found in Article 38, Article 42 of the Revised Penal Code in punishing inciting to commit terrorism under Section 9?
Can you please the question, Your Honor? I wasn't able to get it.
Since inciting is not defined in the law, in the ATA, can we now take the definition and enumeration found in Article 138, inciting to rebellion or insurrection, and 142 of the Revised Penal Code, inciting to sedition, in punishing the crime of inciting to commit terrorism under Section 9?
I don't think so, Your Honor, because the elements of rebellion and sedition are different from the elements of terrorism.
Okay. Do you know what is DABIQ? DABIQ?
I'm sorry, Your Honor. I'm not familiar with the term.
Okay. Please research on that and tell the court if the things found there fall under the definition of inciting to rebellion or inciting to terrorism. These are publications of Islamic groups.
We'll do that, Your Honor.
BABIQ. Thank you, Chief, for giving me this. Chief Justice.
Thank you, Justice Story.
Hindi pa tayo tapos. Mahaba pa tayo, Does the IRI provide parameters in determining reasonable probability of incitement to result to terrorism?
Yes, Your Honor, under Rule 4.9.
4.9. Galing ni ASG. And these are? Can you run it down for us?
In determining the existence of reasonable probability that speeches, proclamations, writings, emblems, banners, or other representations would help ensure success in inciting the commission of terrorism, the following shall be considered: A, context; B, speaker act; C, intent; D, content and form; E, extent of the speech or act; and F, causation.
These items are not found in the law. These are only provided in the IRR. What can you say about it?
We maintain that it's a valid implementation of the ATA, Your Honor.
Is this not a delimitation of the context of the law? Or context of the punishable act?
No, Your Honor, because it assists in determining whether the incitement is likely to happen, Your Honor.
Because there is no definition given by the law as to what inciting means.
Yes, Your Honor.
So the rules can provide for the parameters?
And it can also prevent, Your Honors, the law enforcers and prosecutors from the arbitrary implementation of the law, because it will create the parameters on what
create
a guide,
parang guide, and then even it restricted the application of the law.
Not necessarily, Your Honor, but it provides a reasonable basis on what constitutes inciting and what inciting terrorism.
Does this not amount to undue delegation of legislative power to the executive, who formulated the rules?
Our position, Your Honor, is that no, because under the ATA, one of the powers of the ATC is to properly implement the law, and I think this is a proper implementation of the law, because
and to promulgate the rules and regulations to implement the law.
Proper implementation, Your Honor. I think this is one example of the proper implementation of the law.
Okay. Tayo mahilig tayo sa example, ha? And I think we're aware of this. An ordinary citizen, like a public school teacher, posts on Facebook that he will give 50 million to the one who kills the president. Are you aware? Di ba may ganitong nangyari?
Yes, Your Honor. I read about it.
Can this be considered as inciting to terrorism? Yes or no?
The parameters, Your Honor, it would not be considered because of the position of the speaker or the actor or the status in society.
Why? can the public school teacher not influence people? Okay, let's stop at that. Next example, a politically powerful presidential candidate was defeated in the elections. He then gives a speech insisting that the elections were conducted fraudulently. He called on his supporters to go to Congress, fight and save the country from an illegitimate president. Can this be considered as inciting to terrorism? Yes or no?
I think no, Your Honor,
No, Ren.
because the ano is merely sour graping based on
Did you not consider the character of the one inciting people to go to Congress and make problems there?
Yes, Your Honor, character also is an important consideration.
Consider this another example. 4 individuals come together and decide to bomb a shopping mall in Makati. Fortunately, they were caught by police while planting the bomb and planning the attack. Is it correct to say that they can be punished under Section 6 for planning the commission of terrorism, or Section 7 for conspiracy to commit terrorism, or can they be punished for both?
I think what they have already committed is an attempted act of terrorism under Section 4, Your Honor. And based on the IRR, they can be separately prosecuted for conspiracy to commit terrorism.
And if they successfully detonated the bomb, can they be prosecuted anew for violation of Section 4?
Yes, Your Honor.
At the same time, violation of Section 7, Section 6?
Section 7. Conspiracy, yes, Your Honor.
So they can be prosecuted for violation of Section 4, Section 6, and Section 7.
And for Section 6, Your Honor, because
the bomb was exploded, resulting to deaths of people. Can you make stages of commission of crimes and therefore charge them separately under Section 6, 7, and 4?
based on the IRR, Your Honor, they can be prosecuted only for Section 4 and Section 7.
Okay.
But jurisprudence or in future cases may decide if beyond what is stated in the IRR, they can be prosecuted for other provisions, Your Honor.
Of course, we see the overlaps in this case. It can be the person can be prosecuted under Section 6, Section 7, Section 9, and Section 4. Will this not render the law unconstitutional?
No, Your Honor, because assuming that there will be a possible case of double jeopardy, it will only be a matter of defense for a second prosecution, Your Honor. As held in one case, the existence of possible double jeopardy in a statute will not render that statute unconstitutional, as double jeopardy is only a matter of defense, Your Honor, for a second prosecution.
Is that the position of the government? Or you just prosecute the person to the to the bigger crime rather than include the smaller crimes?
With respect to conspiracy to commit terrorism, Your Honor, based on the IRR, which states that prosecution under Section 7 is not a bar to prosecution under Section 4. That is clear, Your Honor. That is the position of the government.
Is that not violative of the principle of right of the accused against double jeopardy?
No, Your Honor, because the rationale for penalizing conspiracy in itself, independent of other provisions, is that is to deter people, is to deter criminals from getting organized. Because once these criminals are organized, they can launch a collective action that can pose a greater threat to society than an individual attack, Your Honor. That's why it is criminalized in itself, Your Honor, under this law.
Okay. Section 10 of the ATAP punishes persons who voluntarily and knowingly join a terrorist organization. How does the state now account for possibly inactive members?
It will depend on the circumstance of the case, Your Honor, because there is this phenomenon called sleeper cells, which are secretive organizations whose members remain inactive. Then
Inactive meaning inactive.
yes, Your Honor, and they blend with society, and they only become active when called by their leaders, Your Honor.
And
So with respect to this type of members, I believe that they should be considered as member for purposes of prosecution under Section 10, Your Honor.
consider this. A person was a member of the terrorist organization 20 years ago. Ngayon, he is listed there as a member of the terrorist organization. He has cut all his ties now after 20 years and has never taken part in any activity of the terrorist group. What steps must A do to be able to relieve himself from the effects of being listed as a member of that terrorist organization?
One option is for that person to either to publicly renounce or to renounce his affiliation before a competent government agency, Your Honor.
Remember, your organization is listed as a terrorist organization, and you are listed as a member of the terrorist organization. Is a public announcement not enough?
Perhaps that will, Your Honor.
Is it enough?
As long as the public announcement is sincere, Your Honor, and not
Have
mere.
you read the latest pronouncement of the DOJ that they will formally adopt rules for delisting?
I'm not aware, Your Honor.
Are you aware?
Delisting.
No, I just read it, I think the other day, that the DOJ is formulating rules on the listing. And I think this is the listing of somebody who was listed as a member of a terrorist organization, did not participate in any, and would want to clear his name. We would not know what would be the process, whether it will be with the ATC or with the court. That's only an advisement. So we'll have to wait until the DOJ adopts the rules on delisting. Okay. Will the writ of amparo be a relief from a person who wanted to be delisted, or who wanted and he,
the more appropriate remedy, Your Honor, is the writ of habeas data to rectify the list, Your Honor.
or writ of habeas data? Okay. You said in your comment that Section 10 is not an ex post facto law because what Section 10 punishes is new or continuing membership in a terrorist organization. What constitutes a continuing membership as far as the government is concerned?
It means that the person continues to be a member of that organization even after knowledge that that organization has either been proscribed by the courts or designated either domestically or by the United States.
Internationally. So you don't need to join in any in the performance or in the performance of any positive act,
Yes.
which we can classify as acts of terrorism.
Yes, Your Honor. Being a member provides moral support to others, to other people, and encourages them to or strengthens them to conduct their unlawful activities, Your Honor.
Okay. Are you aware of the decision in the Holder case, Holder versus Humanitarian Project,
Yes, Your Honor.
which states that intent to further terrorism is not an element of the crime of providing material support to a terrorist? Are you suggesting that we adopt the same meaning? Providing material support.
The one providing material support that must be aware that the entity or individual that he or she is giving support is engaged in terrorism, Your Honor, or engaged or promotes terrorism, Your Honor. Because if one is not aware that this entity is engaged in terrorism, how can that be considered as providing material support?
Material support. So the person giving support must be aware that the organization he is giving donations to is engaged in terrorism.
Yes, Your Honor. And by giving that support, he is aiding these terrorist individuals or groups, Your Honor.
There are exceptions given in that decision. They are accepting medical or religious materials in that case. And we adopted the definition of material support, except that we did not accept medicine and religious materials. Would you know, or would you have an idea why Congress did not include this in the exception?
Because there is a possibility, Your Honor, that charitable organizations or those engaged in civic in humanitarian assistance may be used as fronts by these terrorist groups for getting supplies, medicine, or funds which they can use for their violent activities, Your Honor.
Is that the view of the government, the general view of the government?
That is because this can be gleaned, Your Honor, and in Section 13 that with respect to the International Committee of the Red Cross and Philippine Red Cross and other state-recognized impartial humanitarian partners, the activities, the humanitarian activities that these groups will undertake will be considered as material support, Your Honor. Therefore, if it is not recognized by the state, there is a possibility that this humanitarian assistance may be considered as material support under Section 12, Your Honor.
So the state is not recognizing the church as an organization providing charitable help, charitable contribution to people?
I'm not aware, Your Honor, of the mechanisms for recognitions under Section 13. Perhaps there may be guidance issued on this, Your Honor.
Who shall issue the guidelines?
I think the ATC, Your Honor, because it is the implementer of the Anti-Terrorism Act, Your Honor.
So it's even Congress is wary of the activities of the church. Is that what you mean?
Your Honor, the perhaps Congress just wants to ensure that the humanitarian assistance that will only be given to those who really need it and will not be utilized or aid violent activities, Your Honor.
Assuming that the church would give to organization, but not knowing that these are terrorist organizations, is that not proper, or will that be allowed?
In that case, Your Honor, if they have not if they are not aware of the unlawful activities of that organization, Honor, I think that they cannot be prosecuted for providing such assistance, Your Honor.
But what will happen is they will be arrested first.
They can raise as a defense, Your Honor, that they have no knowledge that the organizations that they gave to is involved in terrorist activities.
So the government will not invest good faith on charitable institutions, church organizations, providing support to poor people.
No, as long as such support is not given, Your Honor, to identify terrorist organizations, Your Honor.
Let's go now to the hot issue of community pantries. Several officials of the government have made statements associating the organizers of community pantries to the NPA. What is the basis of the government in saying that? Would you have an idea?
I have no personal knowledge, Your Honor.
You have no knowledge that the government, some government officials are associating people with good heart.
Perhaps we can consult the National Security Advisor, Your
Is he
Honor.
around?
Yes, Your Honor.
Okay, we will question him later. We will toss to him the questions later on. I have some questions for General Esperon. So you are not, okay, I think it's better to be answered by General Esperon later on. Now let's go to surveillance. Ikaw ba ang in charge on surveillance?
ASG, Your Honor.
Ikaw ba yung in charge?
No, Your Honor. ASG Carandinas can answer the question.
So surveillance.
Your Honor.
Siya ba talaga? Did I overstep?
May I be excused, Your Honor?
Good afternoon again, Your Honor. Your Honor, please, I think we cannot hear you.
You are on mute.
Can you hear me now?
Yes, Your Honor.
Okay. Do you agree that the state regulations touching on the fundamental right to privacy, such as Section 16 of the law, shall be reviewed using the strict scrutiny test?
We do not believe so, Your Honor.
That the government must choose the strict scrutiny test?
No, Your Honor.
What test must be used in conducting surveillance?
Your Honor, Section 16 on the surveillance, Your Honor, it has been held in the case of Saluday versus People that where a person does not have an expectation of privacy or one's expectation of privacy is not reasonable, the alleged intrusion is not a search that would impinge upon his privacy rights.
Is that a general rule that a person does not expect to be respected of his right to privacy? Or you must be a person in a particular class or in a particular group?
The general, a person's private communications are to be respected.
Okay.
Is Your Honor, the surveillance contemplated by Section 16 is a surveillance conducted after the law enforcement agencies, the law enforcers have secured a consent, have filed a case before the Court of Appeals and have been authorized by the Court of Appeals to conduct surveillance. This is upon a written order from the Court of Appeals. This is an exception to the law, Your Honor.
So in any case, the government cannot undertake surveillance without the authorization from the Court of Appeals.
That is correct, Your Honor.
Is that the position of the government?
Your Honor, a written consent from the Court of Appeals is needed, Your Honor.
Is it not that intelligence reports are obtained by the government through surveillance even without the consent or authorization from the Court of Appeals?
Your Honor, intelligence, when the government presents its case before the Court of Appeals, we would rely on intelligence reports. Intelligent reports. Intelligence reports.
Intelligent reports.
Yes, Your Honor.
What would be the basis of these intelligent reports or intelligence reports? Is it not that a greater part of these reports are generated because of a unsupervised surveillance?
Information reaching law enforcement agents, Your Honor. Confidential informations, Your Honor. That is why we will divulge this before the Court of Appeals so that we would be able to secure a written consent before we conduct the surveillance.
No, what I'm saying is there is previous surveillance conducted, and therefore, on the basis of that reports, you will go to the ATC will go to the Court of Appeals to request for a formal authorization. But in the first place, there is already an informal surveillance conducted.
Yes, Your Honor, from confidential information, Your Honor.
And confidential information are certainly obtained through surveillance. It's not an open report that you hear from people. It's not an open report that is written in the newspaper. It's a report that is obtained confidentially, and confidentiality goes with it an informal surveillance of the person.
We agree, Your Honor.
So that the government is into surveillance, informal surveillance, before going into a formal surveillance to be obtained upon application from the Court of Appeals.
Yes, Your Honor.
Is the government not violating any rules on right to privacy because the government agents are conducting informal surveillance?
We submit, Your Honor, that this is a matter of national security. Yes, Your Honor.
So this is a matter of national security, and therefore,
Your Honor, we believe that there is no law violated by the government in doing so.
Do you think that the order of surveillance under the law is in the nature of a search warrant?
Is it in the nature of a search warrant? It is akin to a search warrant, Your Honor.
In what sense?
Because by virtue of the CA, by virtue of the CA authorization, the law enforcers of the government could establish, after surveillance, we could establish probable cause, and if we have basis to believe from the factual circumstances that we will be gathering after this surveillance, this could lead us to filing of appropriate cases before the Department of Justice, so that the Department of Justice could file cases for a violation of the Anti-Terror Act.
Petitioners claim that Section 16 violates the particular requirement for a valid search warrant under the Constitution. Under Section 18, is the CA required to describe the specific information and data to be obtained under its written order?
The written order of the Court of Appeals, Your Honor, is deemed classified.
It's deemed classified.
Yes, Your Honor.
It cannot be known to anybody?
Your Honor, it is our position that it is classified information as provided for by Section 18 of the ATA, Your Honor.
So it's something that is sealed.
Being classified, Your Honor, it is access to this classified information shall be limited to applicants and duly authorized representatives of the ATC, Your Honor.
In relation to this, can the Supreme Court issue procedural rules to specify the required contents in the CA written order, such as the procedure of obtaining cybercrime warrants? Because the Supreme Court did it in the issuance of cybercrime warrants.
Yes.
We can. The Supreme Court can.
Yes, Your Honor.
So the government is amenable. The government is amenable to the Supreme Court's prescribing rules for the issuance and issuance by the Court of Appeals of an order for surveillance.
Yes, Your Honor.
Like in the manner that a search warrant is being obtained from a judge.
Yes, Your Honor. The government has no objection.
The government has no objection.
Yes, Your Honor.
Ayun na. Section 16 exempts certain privileged communication from the scope of surveillance and interception. Do you hear me?
Yes, Your Honor.
Could you tell us why the exception for priest penitent was excluded in the statute? And do you think the list provided is exclusive?
I believe Your Honor, the list provided is exclusive.
Can you give a guess why the priest penitent communication is not included in the exception?
I could only surmise that it is because of the sanctity of confession, Your Honor.
No, hindi nga in-exclude siya eh. Hindi nga siya kasama sa exception eh.
It is.
It's not. He's not. Like medicines.
Yes, Your Honor. I am sorry.
Do you have an idea why the priest and penitent communication is not excluded?
Your Honor, I withdraw my answer and say that only Congress can answer this question, Your Honor, because they were the ones who crafted the law, and it would be unwise for the executive branch to second guess the wisdom of Congress.
The wisdom of Congress. Very good. Siguro takot sila sa mga priests. Huh?
Baka po.
Are they afraid of the priests?
Siguro po.
Siguro.
Opo.
Section 16 states that the communication of the following may be surveilled: between members of proscribed group, between members of designated group, any person charged with or suspected of committing any crimes punished under the law. What is the quantum of evidence required for the CA in considering that a person can be surveilled?
Probable cause, Your Honor.
Probable cause?
Yes, Your Honor, probable cause.
Marami tayong probable cause. Meron tayong probable cause for search warrant, probable cause for issuing arrest warrant, or probable cause for filing an information in court. Which of that?
Probable cause as defined by Section 17(2) of the IRR, Your Honor. Probable cause, Your Honor, of the ATA, Your Honor.
Okay. Probable cause for? Kasi iba-iba ang level ng probable cause. Probable cause for issuance of a search warrant, probable cause for the issuance of an arrest warrant, or probable cause for the filing of a criminal information before the court.
Probable cause based on personal knowledge of facts or circumstances that evidence which is essential to the conviction of any charge or suspected person for or to the solution or prevention of any such crimes will be obtained. That is what is provided in Section 17, paragraph B2, Your Honor.
Is that a high standard or a low standard of probable cause?
A high or low standard, Your Honor?
Mm-hmm.
Maybe it is a low standard, Your Honor.
Are you sure it's a low standard? Okay. Put that in your memorandum that the court will ask you to.
We will, Your Honor.
Because probable cause has many stages. The court would like to see ano ba yung probable cause as far as the government is concerned in issuing a surveillance order. Must a group be designated first before its members can be subject to surveillance?
Must a group be designated first? No, Your Honor.
What do you mean, no?
Designation under 25 is not a condition precedent for surveillance could be conducted, Your Honor.
So surveillance can be conducted even before designation.
Yes, Your Honor. And in fact, after surveillance, Your Honor, this could in fact lead to a designation.
So surveillance should lead to a designation. It's not the way up. It's not the other way around.
We do not believe so, Your Honor.
What do you mean we do not believe so? What must be the step first? Surveillance or designation? Or designation and then surveillance?
Designation and surveillance, Your Honor, designation is not a prerequisite to surveillance.
Okay.
Surveillance is also not a prerequisite to
for designation.
Yes, Your Honor.
If surveillance is first, what would be the government's basis for conducting a surveillance?
Again, Your Honor, may we reiterate our answer that it is based on reports.
Reports.
Yes, Your Honor. Intelligent reports, Your Honor.
Intelligent reports, the intelligence reports.
Yes, Your Honor.
Intelligence reports are intelligent reports. Because you were saying that a person can be surveilled even before his designation as a terrorist.
Yes, Your Honor. Intel reports is operational surveillance, Your Honor. It is operational surveillance.
Okay. Would you agree, or will the government agree that investigations or information collecting activities conducted on suspected terrorists is prohibited unless there is a CA authorization?
There should always, the law provides that a CA authorization is a condition precedent before conduct of surveillance.
So again, is it the government position that no surveillance can be done without the CA authorization?
Yes, Your Honor. As provided for in section, this is one of the safeguards provided for by the ATA. This is provided for in section 16, that no surveillance can be undertaken unless there is a written authorization from the Court of Appeals.
But you are distinguishing this from the informal surveillance being conducted, which is the basis of the intelligence reports gathered.
Yes, Your Honor. This is communication surveillance, Your Honor, section 16.
We will call that communication surveillance.
Yes, Your Honor.
As differentiated from the surveillance to be authorized by the Court of Appeals.
Yes, Your Honor. Section 16 is communication surveillance, yes.
Okay. As far as the government is concerned, what are the immediate consequences of a designation under Section 25?
Under Section 20, Your Honor, the designation would trigger the power of the AMLC to freeze the assets of the person or the organization designated as a terrorist group, Your Honor.
That's the only consequence?
Yes, Your Honor.
There is no other consequence arising from the designation? Are you sure of that?
Yes, yes, Your Honor. The designation.
Are you not compromising the position of the government? That is the only effect? Designation would only lead to issuance of freeze orders?
Your Honor, 25, when the ATC issues a designation, it automatically adopts. The designation could either be through adoption of the
we're not talking of how a person or an organization is designated as a terrorist. The court is wanting to know the effects of designation. And you said it is only freezing of assets. No other consequences arising from the designation?
It is without prejudice to the eventual filing of an action for prescription.
Okay. Do you not agree that the effects of the ATC designation make the power of designation a judicial function and therefore encroaching upon judicial power?
No, Your Honor.
Why?
This is not a judicial function. ATA is clear, Your Honor, that ATC does not exercise judicial function. This is an administrative procedure that would trigger or that would pave the way for the AMLC to freeze the assets of the designated individual or organization. It is not an exercise of a judicial function, Your Honor.
Designation will not lead to an arrest?
No, Your Honor. There is no arrest after the.
Are you sure of that?
Yes, Your Honor.
Is the procedure for the issuance of a preliminary order of prescription the same as procedure for obtaining a warrant of arrest or search warrant? Ano ba ang procedure ng ATC? To be able to get an order of prescription?
Where the, this is the Department of Justice would file a case before the Court of Appeals for purposes of prescription.
Okay. Yes, we know that.
Yes, Your Honor.
But you know the processes, say the steps to be done by the executive agencies to be able to get an order of prescription from the Court of Appeals. What are the documents? What are the bases?
The DOJ would file a verified application and would
what would be the support? What would be the support? Is just that, is it plainly an application or an application appended with some other things, some other information? If you're not ready, the court, are you ready to answer this?
Section Section 26 provides that the application shall be with the authority of the ATC and upon recommendation of the NICA, the National Intelligence Coordinating Agency, Your Honor.
What the court would like to know is, are there supporting documents, or what are the supporting documents to append the application for prescription? Are you at liberty to tell us? Of course, the application.
Yes, sir.
Other than the application, are there other documents? Probably the confidential reports from the intelligence agencies.
Yes, Lord. Yes, Your Honor.
Are you at liberty to give us some little information about this? Because the court would know how the process is being done.
Your Honor, I
think at least the basic things that need to be known to be able to remember, you are proscribing an organization to be a terrorist organization, and this has consequential effects.
Your Honor, since this is this would stem from a recommendation of the NICA, I believe, Your Honor, that the NICA could be in a better position to answer your question, Your Honor.
Okay. There is no representative from the National Intelligence Coordinating Agency here?
General Esperon, Your Honor.
Ah, General Esperon.
Your Honor, here also, Your Honor.
In the same manner, will the government allow the Supreme Court to promulgate rules for the procedure of prescription and issuance of preliminary order of prescription?
Rules by the Supreme Court. Rules for prescription.
You will think about it.
Your Honor, can we be given a chance to think about this prescription and rules for prescription?
Kanina, very confident ka. You will allow the Supreme Court to promulgate rules. Saan yun?
Surveillance, Your Honor.
The surveillance. But you are now having, you are not sure if you will allow or if you will give us some, or or if you will allow us to give some guidance on how to issue, what procedures to undertake before an order of prescription or order of preliminary prescription can be issued by the Court of Appeals. Remember, the Court of Appeals is within our line of authorities.
Your Honor, since the Supreme Court can promulgate rules concerning protection and enforcement of constitutional rights, pleading practice, and procedure in all courts, then it is our submission, Your Honor, that the Supreme Court, if it wishes to issue rules and regulations regarding prescription,
we can do it.
We will have no objection to that again.
We can do it, okay? Okay, let's leave it like that. So, but you're not sure. Unlike in the previous matter that we've talked about in surveillance, because that's just like issuance of a warrant of arrest or arrest warrant. Okay, let's go to section 29.
Yes, Your Honor.
Do you hear me?
Yes, Your Honor.
Does section 29 mirror circumstances under section 5 of Rule 113 of the Rules of Court?
Yes, Your Honor. This is a detention.
This is a detention
without judicial warrant of arrest, but this is detention following a valid warrantless arrest as contemplated by Rule 5 of Section 5 of Rule 113 of the Rules of Court, Your Honor.
So you added instances where warrantless arrest can be done either by the police officer, the agent of the state, or a citizen.
Yes, Your Honor.
So if we look at the items there, it talks of personal knowledge.
Yes, Your Honor.
Ano naman ang personal knowledge ng ATC dito? Eh, ang nakakita dyan ay police, state agent, or a citizen. Why would ATC issue a warrantless arrest? Hindi naman siya nakakita.
Your Honor, please, the ATC will not issue a warrant of arrest.
Diba sila nag-i-issue niya ng detention?
Detention, yes, but the ATC...
Yeah, warrantless arrest ng 29. Sino ba mag-i-issue niya? Court ba?
No, the authority to detain for...
Exactly.
Yes,
diba? Authority to detain is equivalent to authority to arrest. You will arrest before you detain.
Respectfully disagree, Your Honor, that
pwede mo bang i-detain ang hindi ka you don't effect the arrest?
Yes, Your Honor. There is we detain after the law enforcement agencies would detain following a valid warrantless arrest.
Kaya nga ang sinasabi ko, it's the ATC issuing the authority.
Authority to detain. Yes, Your Honor. Yes, Your Honor. Opo. Opo.
Parang ina-arresto mo yan eh. But yung Rule 113, Section 5, talks of personal knowledge. At least immediate knowledge to the commission of the crime. Oh, ano naman ang alam ng ATC dyan? Hindi naman siya nakakita dyan.
Your Honor, please.
Okay, I think you will find a difficulty in answering this.
No, ang mag-aaresto po are the law enforcers.
Exactly, but the law enforcer does not do it unless there is an authority from the ATC.
Your Honor, please may we respectfully disagree the law enforcers can arrest following by virtue of a valid warrantless arrest. The ATC will not have would have no participation in the arrest. The participation of the ATC would come after the arrest, as the valid warrantless arrest has already been effected, and then the ATC would now participate by allowing the detention for more than 3 days, Your Honor. Pero sa pag-aresto po, wala pong kukunin from the ATC.
Let's read section 29.
Opo.
Can you read section 29?
The provisions of Article 125 of the Revised Penal Code, to the contrary notwithstanding, any law enforcement agent or military officer who have been duly authorized in writing by the ATC has taken custody of a person suspected of committing any of the acts defined and penalized under sections 4, 5, 6, 7, 8, 9, 10, 11, 12 of this act shall, without incurring any criminal liability for delay in the delivery of the detained person to the proper judicial authorities, deliver said suspected person to the proper judicial authority.
Okay, let's stop at that, no? What we are talking about here is detention without judicial warrant of arrest.
Opo. Yes, sir.
Ang nakalagay dito, who having been duly authorized by the ATC. So kailangan may authority muna from the ATC.
Para po for more than the number of days required by 125.
Are you only referring to detention, not effecting the arrest?
Opo. Yes, Your Honor. The detention only po, not the arrest. The arrest would not be, the ATC would have no participation in the conduct of the valid warrantless arrest.
Because this is detention without judicial warrant of arrest.
Opo. Detention, Your Honor.
And then you're saying that the government's position is that Section 29 is a mirror of Rule 113, warrantless arrest.
Opo.
Arrest effected without a judicial warrant. And now you are saying we're only talking of detention beyond beyond what is provided under 125.
Yes, Your Honor.
Yun lang yun?
Opo. The law enforcers would arrest by virtue of a valid warrantless arrest following the guidelines set forth by Rule 113. If the law enforcers have already effected the arrest and they think that they could not file, or the evidence are not yet sufficient for them to validly file a case before the prosecutor's office, then they would have to secure a permission from the ATC so that to detain the person arrested beyond the period contemplated by Article 125 of the Revised Penal Code, Your Honor.
So that's the position of the government?
Yes, Your Honor.
And that is not what is written in the law?
May we respectfully,
Okay, can you expound on this, Section 29?
We will do so, Your Honor.
Because this is a very contentious provision.
Yes, Your Honor, we will do so.
The government would like to see the position of the government on this.
Yes, Your Honor, we will do
Right?
so. Yes, Your Honor.
Is it not that the written authorization from the ATC is like the assessed approximate the arrest and seizure warrants issued during the martial law? Because these are warrants of arrest without the participation of the court.
We submit that this is not like martial law, Your Honor.
No. We're not, I am just likening it to arrest and seizure and search order during the martial law, because at that time, the executive can issue the arrest and search order without judicial intervention. The court is wanting to know or wanting to be clarified that the written authorization of the ATC is not like or is like an ASO during the martial law. We're not talking of martial law here.
Yes, Your Honor.
Only the instrument.
We submit, Your Honor, that this is not like the ASO, Your Honor. It is no warrant is issued by the ATC, Your Honor. It is just the authority to extend the detention, Your Honor.
That is the only thing that Section 29 speaks of.
Yes, Your Honor.
Warrantless under 113 and continued detention beyond 125.
Yes, Your Honor.
By virtue of the authorization given by the ATC.
Yes, Your Honor.
Is that the proper interpretation that I get from you?
We submit that that is the government's interpretation, Your
That's
Honor.
the government interpretation.
Yes, Your Honor.
So you have to be very, very clear in discussing the authorities of the ATC under Section 29.
Yes, Your Honor. That in our memorandum, Your Honor.
So let's go to detention beyond 3 days. Ito yung sinasabi mo.
Yes, Your Honor.
The authority under Section 29 only speaks of detention beyond 3 days.
Yes, Your Honor.
Under the Constitution as provided for, or under Article 125 of the Revised Penal Code.
Under Article 125 of the Revised Penal Code, Your Honor.
And then we have the 3-day rule if the suspension of the habeas corpus is done under the Constitution.
Yes, Your Honor.
Why you have to deliver the arrested person to the judicial authorities within 3 days?
Under Article 6, Section 18, Your Honor, yes. Yes, Your Honor.
Article 7, Section 18 of the Constitution, you have to deliver the person to the judicial authority within 3 days, even at a time when the habeas corpus the writ of habeas corpus is suspended.
Yes, Your Honor.
Does this 24-day period not contravene the intent of the constitutional framers in providing for the absolute ceiling of 3-day detention?
We believe, Your Honor, that it does not.
Why?
Congress, because of its rulemaking, Congress, the exercise in Congress in passing the ATA, realized that the 3-day period for building up a case for terror, building up an terror case is not sufficient, Your Honor. This is because of their previous experience wherein they would have to finish investigation because of the 3-day limitation period, Your Honor.
What? Congress by its power.
This is within the power the setting of this period beyond the 3 days is within power, is an exercise of the legislative power, Your Honor.
Does it not violate the constitutional provision I have already mentioned with respect to the maximum day of detention, even at a time when the writ of habeas corpus is suspended?
Your Honor, it is our submission that the constitutional provision on applies only to insurrection, rebellion, or invasion. It does not apply to other crimes. And because of Congress can pass a law setting another
period of detention, long detention,
for other crimes like this one, as it did in this Anti-Terror Act, Your Honor.
Sandali lang. After a 20-day period detention and nothing has happened, is that detained person to be released automatically?
Immediately released.
So the longest period of detention without any charge is 24 days.
Yes.
After 24 days and there is no charge, the government cannot, or the ATC cannot reissue another order of arrest or order of detention.
After the lapse of the 24 days, Your Honor, the person must be released. Yes, yes, Your Honor.
Kung designated siya as a terrorist, but there is no proper charge against him under Section 4, under Section 7, under Section 6, under Section 9. What happens to him?
Your Honor, if only through designation is not tantamount to or would not give rise to an arrest. It would not result to an arrest, Your Honor.
A designation would not result into an arrest, much less into a 24-day prolonged arrest. That is your position.
Yes, Your Honor. Yes, Your Honor. The designation contemplated by 25 is different from the provisions. Section 25 is different from Section 29 because designation per se cannot lead to an arrest, nor could it result to a detention. Designation per se, Your Honor, cannot lead to an arrest or detention.
Okay, that is, designation does not lead to an arrest
or detention, Your Honor.
Because as what you said, designation would only result into the
it would result to the
freezing of assets only.
But this without prejudice to the eventual filing of a prescription case, Your Honor.
Yun na nga eh. Prescription case, the member is a member of that proscribed organization.
Opo.
Will the evidence gathered by the ATC to be able to get a designation that a person is a terrorist different or the same in filing a case against him for either Section 6, Section 7, Section 9, assuming that there is no terrorist act done? It does not qualify under Section 4. will the evidence, I will repeat, will the evidence obtained or gathered to designate a person as a terrorist one be the same or different to charge a person under Section 6, Section 7, Section 9. Of course, kung mayroong Section 4, there is already an overt act.
Yes, Section 4, Your Honor, there would. May I?
Okay. So I think you are not ready to answer this, but I think the question of the court is very clear. You clarify that in the memorandum that the government will submit.
Yes, Your Honor.
Meron pa ba tayo? So it is the position of the government that after a 24-day detention, and there is no charge, the person will be released automatically.
Yes, Your Honor.
The petitioner says that there was railroading in the passage.
I am sorry, Your Honor.
Did you not hear me?
Yeah. Your Honor, could you kindly repeat the question, Your Honor?
The petitioners say that the passage of the law was railroaded and attended by grave abuse of discretion. What can you say about this?
Your Honor, we disagree with the position of the petitioners, Your Honor.
Why?
I believe that this law was several months before this law was passed, and therefore we believe that this law was carefully deliberated by the members of Congress.
No, I refer you to Article 6, Section 26 of the Constitution, paragraph 2. The President's certification of a bill to be passed into a law is only an urgent matters limited to public calamities or emergencies. Would you say that prevention of a terroristic act satisfy the requirement of public calamity or emergency?
Yes, Your Honor. Emergency, yes, Your Honor.
Urgency, emergency, urgency.
Yes, Your Honor. That is why the President certified this bill as
urgent.
Yes, Your Honor.
And when the bill is certified as urgent, there are certain fast procedures being done.
Yes, Your Honor.
Okay.
Versus Macapagal Arroyo, yes, Your Honor.
Chief.
Yes, Justice Rory, you still have another question?
I'm through with the Office of the Solicitor General. Siguro we will ask General Esperon, or I will leave this to you to ask General Esperon on the next hearing.
Justice Rory, you have all the time for the next session to continue your interpellation on the Respondents' Counsel as well as their resource person.
So we are suspending the orals now.
Yes, it's already 4:30. We can suspend the adjourn temporarily
4:30
to resume
o 5?
next Tuesday.
Ano bang oras? 5:30 na pala.
Yes.
5:30.
Yeah.
There is a request here of
Attorney Colmenares,
yes.
we'll allow him to make the appropriate manifestation as he requested.
Now?
Yes, before adjourning the session.
So
Thank-
okay, we will call him.
Yes. Go ahead, Attorney Colmenares.
Thank you, Chief Justice. Maraming salamat po. The opening statement of the respondents to prove their case that terrorism is evil mentioned about the supposed raid where an armory or cache of arms and weapons were found. Along the way, the respondents mentioned that in this armory are election campaign materials for me when I ran for the Senate, for other party list groups and other candidates, Your Honors. I believe, Your Honor, that this does not constitute a crime, even if true. If true that there were guns found, and this could not be taken as truth for now because of many allegations in previous searches of planting of evidence, but even if true, and even if true that campaign paraphernalia with my name and the other candidates there are found, that does not constitute a crime, Your Honor. And therefore, the imputation of a crime, implicating me in a crime, in the mention and the opening statement, I believe is uncalled for. I saw in the TV that raid, Your Honor, and there were in fact the military claims. There were election paraphernalia bearing my name, that of Senator Bam Aquino and other party list groups. But that does not mean that we committed a crime. The action, if any, of any person campaigning for another candidate, any crime committed by that person campaigning for a candidate cannot be imputed on the candidate he or she is supporting. So I do not see the reason why my name, the name of other candidates were mentioned there. The respondents may say, oh, well, just stating a fact, we're not really implicating you in a crime. So what's the use, Your Honor, of mentioning my name? This is red tagging then in the end. Your Honor, if in ordinary times, red tagging may be considered a libelous statement. But now, Your Honor, red tagging is a deadly offense. It is a threat to life, liberty, and security. And I really feel that this mentioning of our names, of candidates, are really uncalled for when the respondents want to establish the evilness of terrorism and the crime of terrorism, because we have no relations at all to terrorism. And the fact that campaign paraphernalia were found, even if true, does not constitute an offense, Your Honor. And I would like for the court to consider in my manifestation that this should not have been mentioned, because for people like us, this is red tagging and this is dangerous, Your Honor. So thank you, Your Honor, and that is just my manifestation. The fact that our paraphernalia, if true, were found there, it does not mean we're terrorists. And mentioning us in the opening statement implicates us in that crime, and that is very dangerous for us, Your Honor, and another type of red tagging. Maraming salamat po. Thank you. I will try to file a written manifestation after this, Your Honor, if the court will allow. Thank you.
Thank you, Attorney Colmenares. The manifestation is duly noted. Considering it's already 5:30 in the afternoon for lack of material time, today's session is adjourned and to resume on May 3, 2021 at 2:30 p.m.
May 3 or May 4, Chief?
May 3. What's next Tuesday? May 4?
May 4.
May 4, sorry. Shall continue on May 4 at 2:30 p.m.
May 4.
Parties are notified in open court. Adjourn the session.
Please remain in your respective seats while the Chief Justice and the Associate Justices leave the virtual session hall.